Committee on Oversight and Government Reform will come to order. Pursuant to Committee Rule 5B and House Rule 11-2H4, the Chair announces that he may postpone further proceedings today on any question of approving any measure or matter or adopting an amendment on which a recorded vote or the yeas and nays are ordered. And without objection, the Chair is authorized to declare a recess at any time. So let us go ahead and begin. The first item for consideration is H.R. 653. The clerk will designate the bill.
H.R. 653, to amend Section 552 of Title V, United States Code, commonly known as the Freedom of Information Act, to provide for greater public access to information and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. The Freedom of Information Act of 2015 strengthens freedom of information and will help ensure transparency and disclosure of information is timely, accurate, and routine. The FOIA bill will make government more transparent and accountable to the public, and I appreciate the work of former Chairman Darrell Issa and Ranking Member Cummings in reintroducing this measure, which passed the House by a vote of 414 to nothing in the last Congress. I now recognize the ranking member for 5 minutes for any statement on the bill and thank him for his good work and passion on this issue, and we enjoy working with him and his staff in crafting this bill. We appreciate the good work as he's the prime sponsor here with Chairman Darrell Issa.
Thank you very much, Mr. Chairman. The Freedom of Information Act is one of our most important open government laws. I'm happy to be joining Representative Darrell Issa in sponsoring the FOIA Oversight and Implementation Act again this Congress. This bill, if passed, would be a landmark reform of the law. Last Congress, the FOIA Act passed the House with a unanimous and bipartisan vote of 410 to 0. Mr. Chairman, I appreciate you bringing this bill up so quickly to this Congress. I also appreciate your staff and all the hard work that they've put into making it a better bill. FOIA reform came very close to becoming reality last Congress. The Senate passed a similar bill by unanimous consent in December, but we did not get a bill over the finish line. There is widespread support for passing the FOIA Act. Mr. Chairman, I ask unanimous consent to include in the record a letter sent to myself and Representative Issa from 47 open government organizations in support of this bill.
Without objection, so ordered.
I would also like to include in the record a New York Times editorial from February 18, 2015, titled "A Stronger Freedom of Information Act." That editorial said, and I quote, "For Republicans, this is a rare chance to log a significant bipartisan accomplishment in the public interest, one that Mitch McConnell, the Senate Majority Leader, and Mr. Boehner should promptly seize. The availability of information that sheds light on the workings of government is essential for a healthy democracy. Strengthening the law will help ensure that basic principles of transparency are not a matter of executive discretion." One of the major reforms made by the FOIA Act would be to put into statute a presumption of openness. During the Clinton administration, Attorney General Janet Reno adopted a policy under which the Department of Justice would defend an agency's use of FOIA exemption only when the agency could reasonably foresee that the disclosure would harm an interest protected by that exemption. In the Bush administration, Attorney General John Ashcroft reversed the standard and directed the Justice Department to defend agency decisions to withhold records as long as it had a legal basis for doing so. President Obama, on his first day in office, directed agencies to implement FOIA with a presumption of openness. Attorney General Holder overturned the Ashcroft standard and reinstated the foreseeable harm standard. The legislation before us today would codify in law this presumption in favor of disclosure no matter who is president. Under this bill, an agency would not be allowed to withhold information in response to a FOIA request unless disclosure is prohibited by law or would cause specific identifiable harm to an interest protected by one of FOIA's exemptions. The FOIA Act would place a 25-year sunset on the Exemption 5 of FOIA. This means that an agency would only be able to keep a document secret for 25 years under the rationale that the document would reveal the agency's deliberative process. The bill would also strengthen the independence of the Office of Government Information Services, which serves as the government's FOIA ombudsman, by allowing it to send testimony and reports directly to the Congress. These are just a few of the ways the FOIA Act will strengthen the law. Mr. Chairman, I also want to express support of the substitute amendment. I appreciate the bipartisan work that has been done to make further improvements to the underlying bill. Earlier this month, committee staff received an update from the General Services Administration team that has been working on a prototype for a consolidated FOIA request portal. In the course of that research, yesterday's team found that not all agencies currently accept FOIA requests by email. This amendment would require every federal agency to accept requests for records under FOIA through an email address and to publish that email address on the website of the agency. This provision would make the process of submitting a FOIA request easier. The substitute amendment also makes technical corrections to the language in the bill that outlines the responsibilities of the Office of Government and Information Services. These corrections would allow OGIS the discretion to issue advisory opinions upon requests of any party utilizing that office's mediation services. H.R. 653 provides long overdue and necessary reforms to strengthen FOIA. This amendment improves the bill, and I strongly support it, and with that, I yield back.
Thank the gentleman for his good work on this, and again, I do appreciate the staff work that's being done on both sides of the aisle to come together on these. Before we move to this amendment, the Chair wishes to advise members that we do intend to recess roughly 10:30 for the President of Afghanistan addressing the Congress, so we want to make sure that members have an opportunity to attend that in a timely way. Also advise members that we do plan, if there is a recorded vote, that we plan to roll those, and we should give you a 15-minute notice as to when that will happen. Do any other members wish to speak on the bill? We're now ready to start the amendment process. Are there any other amendments to the bill?
Mr. Chairman,
Do you have
I have an amendment in the nature of a substitute.
Without objection, the amendment will be considered as read. The clerk will designate the amendment to the ANS.
Amendment in the nature of a substitute to H.R. 653 offered by Mr. Meadows. Strike all after the enacting clause and insert the following. Section 1, short title. This act may be cited as the FOIA.
Mr. Chairman, I move that we dispense with reading, consider it as read.
Without objection, so ordered. Gentleman from North Carolina is recognized for 5 minutes to describe his amendment.
Mr. Chairman, I'll be very brief. At your direction, this committee had a hearing to talk about FOIA and really hear from Miriam Nisbeth with regards to how to clarify the FOIA and FOIA process and speed that up. The ranking member has eloquently laid out this bipartisan, not only bipartisan legislation, but certainly this amendment in the nature of a substitute, which would provide OMB to establish a single website, make it much easier for FOIA requests. I believe this is in keeping with the testimony we've already heard on this hearing, and I urge all my colleagues to support this amendment in the nature of a substitute. I yield back.
Thank the gentleman. Does any other member wish to speak on this amendment?
Mr. Chairman,
Yes.
I support this amendment in the nature of a substitute, and I'll have no additional comments. I think I said it all in my opening statement.
Does any other member wish to be heard on this amendment? I have an amendment to the amendment in the nature of the substitute. The clerk will designate the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 653 offered by Mr. Chaffetz of Utah. Page 4, strike lines 7 through 12, and insert the following.
I ask unanimous consent the amendment be considered as read. It should be in your binders at your desk. I will recognize myself for 5 minutes to explain the amendment, and without objection, the amendment will be considered as read. The amendment prevents agencies from withholding documents under the deliberative process privilege that were either, 1, created for the purpose of making a decision but not expressly adopted by the agency in the final decision, 2, records used to guide agency employees on how to interact with the public, or 3, controlling legal interpretations. The amendment prevents agencies from hiding controlling law in the executive branch under the guise of legal privilege, an all too common practice. One example of this comes from the Office of Legal Counsel within the Department of Justice. This small office provides, quote, controlling legal advice, end quote, to the executive branch, and the OLC is, quote, frequently asked to opine on issues of first impression that are unlikely to be resolved by the courts or circumstances in which OLC's advice may effectively be the final word on the controlling law, end quote. Despite this very important role, many of OLC's legal memorandum are currently confidential and unavailable to the public, even though they determine the legal parameters of the agency's policy options. One key goal of this amendment is to help shine the light on these amendments. The American people have the right to know how the government is interpreting the law. Moreover, courts currently interpret Exemption 5 to include pre-decisional records that the agency does not expressly adopt in the final policy. This would also change under this amendment. When agencies solicit studies, analysis, or specific advice, the information received in response serves as an important basis for resulting policy decisions. We just believe that this should be part of the public record. And with that, I will yield back. Does any other member wish to be heard on this amendment?
Mr. Chairman.
Yes, Mr.
Thank you very much, Mr. Chairman. I appreciate the intent of the amendment. I will support it. I understand that the intent of this amendment is to narrow the scope of information that agencies can designate as deliberative and thus withhold under Exemption 5 of FOIA. I had concerns with this amendment as it was originally drafted because it would have covered broad categories of information that I believe would have covered more than we intend. I appreciate you working with me, and also I appreciate your staff working with my staff to narrow the scope of the amendment. I am glad that we were able to reach a compromise. We should continue to examine the potential impacts of this amendment as we move forward, and with that, I yield back.
I thank the gentleman. I do appreciate working with him and his staff, and I do think we have consequently a better amendment. Any other member wish to be heard on this amendment? If not, the question is now on the amendment to the amendment offered by myself. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Are there any other further amendments to the amendment? Because I happen to have one. The clerk will designate the amendment. Amendment number, Chaffetz number 2.
Amendment to the amendment in the nature of a substitute to H.R. 653, offered by Mr. Chaffetz. Page 4, after line 19.
Ask unanimous consent to consider the amendment as read. Without objection, so ordered. I'll recognize myself for 5 minutes to explain the amendment, and without objection, the amendment will be considered as read. Currently, courts may require agencies to pay plaintiffs' attorney fees when the plaintiff prevails against an agency in a FOIA proceeding. This amendment makes a small but important change to the Freedom of Information Act offered by Mr. Issa and Mr. Cummings. It changes one word. Instead of may, it changes it to shall. This change will ensure that when a court determines the government incorrectly responds to a FOIA request, the requester doesn't have to pay. Federal agencies have a duty to be fully responsive in providing documents to citizens, and public should not be required to be penalized for enforcing their own rights. This common sense amendment supports the presumption of openness regarding FOIA disclosures that are included in the base bill. The amendment serves as an additional incentive for agencies to properly comply with FOIA requests in a timely manner so the litigation can be avoided altogether. I would urge my colleagues to support this amendment. Gentleman from Maryland, the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. I will not oppose this amendment. I do, however, want to express some concerns that I believe should be carefully considered before this bill goes to the floor. And Mr. Chairman, as one who practiced law for many years, I've always been in favor of courts having discretion because I think there are certain circumstances that may come up that we cannot foresee that that one adjudicating an issue might be able to see on a case-by-case basis. But be that as it may, under the current FOIA law, courts have discretion over whether to require agencies to pay attorneys' fees and other litigation costs in cases in which the complainant has prevailed. Your amendment would require courts to make agencies pay for the fees and the litigation costs incurred when the agency does not prevail in a FOIA case. Of course, I want openness, and I like the idea that if one prevails, that they be able to get attorney's fees because they deserve it, and they, probably, and attorney's fees are not cheap. But anyway, the best practice is generally to provide courts with the discretion to award attorney fees when it is appropriate. I think we need to carefully consider the implications of taking that discretion away from the courts. And with that, Mr. Chairman, I yield back.
I thank the gentleman. Does any other member wish to be heard on this amendment?
Mr. Chairman,
Gentleman from South Carolina.
move to strike the last word. Of course, I'm going to support the chairman's amendment primarily because he is the chairman. But before it goes to the floor, is there any way we could study how many denials of attorney fee applications have been made under this permissive standard?
The gentleman makes a good point. We intend to work with Mr. Cummings and the minority staff as well as yourself, and I think it's a very appropriate question, and I hope to have the answer to that prior to bringing it up on the floor.
Thank you, Mr. Chairman.
Thank the gentleman. Does any other member wish to be heard on this amendment? If not, the question is now on the amendment to the amendment offered by myself. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. Are there any further amendments to the amendment? Gentlewoman from New York.
I have an amendment at the desk.
Clerk will designate the amendment to the amendment in the nature of a substitute, offered by Ms. Maloney.
Amendment to the amendment in the nature of a substitute to H.R. 653, offered by,
I ask unanimous consent that the amendment be considered as read, and now the gentlelady from New York is recognized for 5 minutes to explain her amendment, and without objection, the amendment is considered as read.
Thank you, Mr. Chairman. My amendment is simple, but it's critically important. The amendment clarifies that nothing in this bill is intended in any way to undermine or weaken the safeguards that Congress put in place to protect the integrity of the supervisory process for financial institutions, and ultimately to protect the safety and soundness of the financial system. Currently, the financial regulators rely on Exemption 8 in the Freedom of Information Act to protect sensitive, confidential information that they receive from financial institutions and banks. Congress has always recognized that this exemption is necessary and fulfills two important purposes. First, protecting the safety and soundness of financial institutions, and secondly, ensuring that there is a free flow of information between financial institutions and their regulators. It's this second purpose underlying Exemption 8, ensuring the free flow of information, that is an issue here. Financial regulators need all of the information, good and bad, from their financial institutions in order to properly do their job. The financial regulators are concerned, and I share the concerns, that this bill would take away their ability to withhold confidential supervisory information solely to protect the free flow of information between banks and their regulators. If that happens, then the financial institutions will be less candid with their regulators and less likely to share important information. And this is information that the regulators need to do their job. I do not believe that that is the intent of the bill, and I commend Ranking Member Cummings, Mr. Issa, and Chairman Chavez for their terrific work on this bill. So my amendment simply adds a rule of construction that clarifies that the intent of the bill is not, in fact, to lessen the protections provided by Exemption 8. I have spoken with the chairman, and the chairman is not prepared to say yes to this amendment yet. So I am going to withdraw the amendment and ask the chairman if he would be willing to work with me on this issue as we prepare to go to the floor. And I hope to hear a positive response from the chairman.
If the gentlewoman would yield, I do appreciate her commitment to this issue, something I know that's near and dear to her heart and that she's worked on. I do intend to work with you and your staff as we move this bill to the floor. I think you bring up some very good and valid points that need further discussion, but I do look forward to continuing to work with you.
Well, therefore, I will withdraw my amendment, and I look forward to working with Mr. Cummings and with the chairman. Thank you.
Mr. Chairman.
Gentleman from Maryland.
Chairman, I want to encourage you as we move forward with this bill to ensure that the concerns raised by Representative Maloney are acknowledged. I appreciate her willingness to withdraw her amendment today with the understanding that we will continue to work together. Mr. Chairman, would you be willing to commit to Representative Maloney that the committee's report will include language addressing the concerns she's raised?
Yes.
Thank you very much. I yield back.
Thank you. Without objection, the amendment is withdrawn. Are there any further amendments to the amendment? If none, the question is now on the amendment in the nature of a substitute offered by Mr. Meadows as amended. All those in favor signify by saying aye. Aye. All those opposed, no. In the opinion of the chair, the ayes have it, and the amendment is agreed to. The question is now on adoption and favorably reporting H.R. 653 as amended to the House of Representatives. Those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. The next item for consideration is H.R. 901, offered by Mr. Meadows of North Carolina. The clerk will designate the bill.
H.R. 901, to prohibit accessing pornographic websites from federal computers and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. H.R. 901 brings needed accountability to the federal workplace, requiring OMB to issue guidance prohibiting the access to pornographic or explicit websites on a federal computer. While it is disappointing the bill is even necessary, given the recent incidents of federal employees accessing pornographic sites, something has to be done. I thank Mr. Meadows for his work on this bill, and now recognize the gentleman from North Carolina, Mr. Meadows, for 5 minutes to explain the legislation. Mr. Meadows.
Thank you, Mr. Chairman, and thank you for bringing this up for markup today and for your leadership. As you so accurately put it, it's a shame that we would even have to be considering a piece of legislation to address this issue. You know, healthy, safe workplaces is what all of us want. It is a bipartisan issue. It's been interesting as we have looked at this particular bill and essentially trying to make sure that what is common sense for the vast majority of Americans, that you should not be watching pornography on the taxpayer dime, is something that we recognize not only as a federal agency but in workforce enforcement. We heard at a hearing here in this particular room of employees who for hours and hours and hours viewed pornographic material, not even losing their job because of the limitations that currently exist within the federal workforce. And so I certainly appreciate the leadership that the chairman has shown, his willingness to bring this up, and I encourage all my colleagues to support H.R. 901.
Thank the gentleman. Now recognize the ranking member for 5 minutes and a statement on the bill.
Thank you very much, Mr. Chairman. I understand that the Government Operations Subcommittee Chairman Meadows introduced H.R. 901, the Eliminating Pornography from Agencies Act, in response to allegations that employees of the Environmental Protection Agency were watching pornography on their workstation computers. Such conduct is totally unacceptable, and I agree with Mr. Meadows that this is something that we must address. The legislation before us today would require the Director of the Office of Management and Budget to issue guidelines that prohibit federal employees from accessing pornographic websites while at work. While I appreciate Congressman Meadows' work on the legislation, The misconduct he seeks to address in the measures already prohibited under the standards of ethical conduct for federal employees. The Ethics Code states, and I quote, "An employee has a duty to protect and conserve government property and shall not use such property or allow its use for other than authorized purposes," end of quote. Although I do not oppose Mr. Meadows' legislation, it is, I just don't think that it's necessary, but if we want to make sure that we send a message, and I think that's what it does, I have no objection.
I thank the gentleman. Does any other member wish to speak on the bill? Let me simply say I appreciate Mr. Meadows bringing up this bill. This is one of the good things I think that came from our committee, is that we heard and listened to the EPA administrator talk about the problems, and we asked why they couldn't fire this person. She said she needed help. She needed assistance. She needed strengthening in the law, and if to that end, if this will help her, I think this is a much needed bill. So does anybody wish to offer an amendment to this bill? If there are none, the question is now on the adoption and favorably reporting H.R. 901 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it, and the bill is ordered favorably reported. Without objection, a motion to reconsider is laid on the table. The next item for consideration is H.R. 1069. The clerk will designate the bill.
H.R. 1069 to amend Title 44 United States Code to require information on contributors to presidential library fundraising organizations and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. H.R. 1069 would require presidential library fundraising organizations to disclose information regarding donors who contribute more than $200 each quarter to the National Archives, who in turn would make the data available to the public. I thank Mr. Duncan for his continued leadership on this bipartisan bill, co-sponsored by Ranking Member Cummings. Earlier versions of this bill have passed the House in 3 different Congresses, but we haven't been able to get it over the finish line, and hopefully this Congress and this Senate will be a bit different. I now recognize the gentleman from Tennessee, Mr. Duncan, for 5 minutes to further discuss the legislation.
Well, thank you very much, Mr. Chairman. Thank you for taking up this bill, and you are correct. This bill has passed the House 3 times by overwhelming margins. The first time it was passed, I had sponsored the bill. It was during the administration of the second President Bush, and it passed by a vote of 392 to 3. It's gotten similar support in 2 later Congresses, and it's about the most bipartisan bill that you could ever come up with, because in the second time it passed, that bill was my original bill was sponsored by Chairman Waxman, and then much to my appreciation, in the third time it was sponsored by Chairman Towns. And this is a good government bill. I do have a little more optimism or hope for this bill this time, because since the last time it was passed, it has been endorsed by Juan Williams on Fox News one night, and also a favorable article was written about it in USA Today, and it's now been endorsed also by several leading organizations that we haven't had before. I first became interested in this when I read a front page story in the Washington Times that some governments in the Middle East were making multi-million-dollar contributions to presidential libraries, and these contributions are being made while the presidents are still in office. And then it came out later that President Clinton, on his last day in office, had given a pardon to Mark Rich, who fled the country to evade $40 million in taxes after his ex-wife had contributed $450,000 to his library. But this is not and should not be a partisan bill. It's just a bill. It's very simple. Just requires the same as we're required to report our campaign contributions. This would require that these contributions, any contribution over $200, be reported, and I think it's I think it's a good bill, and I urge its support. I yield back.
I thank the gentleman. Now recognize the ranking member, Mr. Cummings, for 5 minutes.
Mr. Chairman, I wanted to start by thanking Representative Duncan for his leadership on this legislation and for sticking with it. I'm pleased to be an original co-sponsor of this bill, which will bring transparency to the funding process that supports the construction of presidential libraries. Presidential libraries are funded through private donations, and presidents often begin fundraising for their libraries while they are still in office. President George W. Bush raised more than $500 million for his library, museum, and institute. The facility itself cost about $250 million. President Clinton's library cost an estimated $165 million. These libraries were built with donations from undisclosed contributors. The bill simply says that the identities of those who donate to support a presidential library should be disclosed. The bill has passed the House several times. It should be law by now. I hope that this time around it will finally make it to the President's desk. And with that, I yield back.
Thank the gentleman. Does any other member wish to speak on the bill? Gentlewoman from the District of Columbia is recognized for 5
Yes,
minutes.
Mr. Chairman, I'm strongly in favor of the transparency that's clear in this bill, and I must comment that we want who contributes to the president while he's in office, who contributes to the president after he leaves office, but we've had a hard time getting transparency on who contributes to the president as he's trying to become president. It seems to me we ought to go straight across the board on transparency. Thank you, Mr. Chairman.
Thank the gentlewoman. Does any other member wish to be heard on this bill? Are there any amendments to the bill? If there are none, the question is now on adoption and favorably reporting H.R. 1069 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. No. Then, in the opinion of the chair, the ayes have it, and the bill is favorably reported. Without objection, the motion to reconsider is laid on the table. The next item for consideration is H.R. 1562. The clerk will designate the bill.
H.R. 1562, to prohibit the awarding of a contractor grant in excess of the simplified acquisition threshold unless the prospective contractor or grantee certifies in writing to the agency awarding the contractor grant that the contractor or grantee has no seriously delinquent tax debts and for other purposes.
I ask unanimous consent the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. H.R. 1562 simply states that if contractors and those applying for grants don't pay their taxes, they will not be eligible for federal contracts or grants. I'm pleased to again introduce H.R. 1562 with Representative Speer, as we did in the year 2013. That bill passed the House by a vote of 407 to nothing. But unfortunately, the Senate did not act. The bill has long had bipartisan support, including from President Obama, who in 2007, as senator, introduced legislation to address this contractor accountability issue. Those who would consciously ignore the rules and fail to fulfill their tax obligations must be held accountable. I'm very much in favor of this bill, having introduced it, and I'm pleased to, like I said, having reintroduced this with Ms. Speer and working with her. A couple other notes that I would like to make. The GAO has found that thousands of federal contractors with substantial amounts of unpaid federal taxes. In fact, the GAO reported about 27,000 Department of Defense contractors owed roughly $3 billion in back taxes. 33,000 civilian agency contractors owed $3.3 billion in back taxes, and 3,800 GSA contractors owed $1.3 billion in back taxes. Not all contractors are tax cheats. In fact, the vast majority pay their taxes. They're patriotic. They do so on time and in full. And you have people who have issues that they're challenging, that they don't believe that they're owed. They're going through that adjudication process. But many fulfill very dangerous missions, investing in cutting-edge technology and provide assistance to poor and others in need. But these contractors who don't play by the rules, they should be held accountable. And unfortunately, despite their past efforts, we haven't been able to get this bill over the finish line. The President has issued some directives, but we are trying to codify this into law. It just seems fair. It just seems right. As the President has said, and let me read a quote from him. This is, when it was Senator Obama, he introduced this bill. That's quite frankly where I got this idea. I thought it was pretty clever to go see what Senator Obama liked, and I found one that I liked. And so I introduced it as my own since he was no longer in the Congress. And so as we moved it forward and he became the President, he issued on January 20th, 2010, it says, President Obama directs the administration to crack down on tax cheats seeking government contracts. Quote from the President. By issuing this directive, all of us in Washington will be required to be more responsible stewards of your tax dollars. All across this country, there are people who meet their obligations each and every day. You do your jobs, you support your families, you pay the taxes you owe, because it's a fundamental responsibility of citizenship. The steps I'm directing today and the steps I'm calling on Congress to take are just basic common sense. I'll go ahead and close the quote there because I think the President is right on this issue. I can't say that he has endorsed this piece of legislation, but having sponsored it before as a senator, and certainly the statements that he's made since he's President, I think we're on good common ground here and would urge my colleagues to support this bill. With that, I'll now recognize the ranking member for 5 minutes for any statement on the bill.
Thank you very much, Mr. Chairman. H.R. 1562 is nearly identical to a bill introduced in the last two Congresses by you, Mr. Chairman. It's very similar to legislation reported by this committee and passed by the House in the 110th Congress. I support this legislation each time it has been introduced, and I continue to support it now. The Government Accountability Office has reported that government contractors owed more than $5 billion in unpaid federal taxes in 2004 and 2005. Unpaid taxes owed by contractors include payroll taxes, amounts required to be withheld from employees' wages, as well as corporate income taxes. GAO has found that some contractors with unpaid tax debts are repeat offenders that have failed to pay their taxes over many years, including in one case for almost 20 years. The legislation will allow the federal government to make sure that contractors seeking to do business with the federal government have paid their taxes before they can receive a federal contract. The Federal Acquisition Regulation was revised in 2008 to require contractors to certify that they do not owe a delinquent tax debt to the federal government. This bill builds on that requirement by providing federal agencies the means to verify contractors' claims. This legislation will also ensure that responsible contractors no longer have to compete with tax delinquents. With that, Mr. Chairman, I support it and I yield back.
Thank the gentleman. Do any other members wish to speak on the bill? Does any member wish to offer an amendment to the bill? If there are none, the question is now on adoption and favorably reporting H.R. 1562 to the House of Representatives. All those in favor signify by saying aye.
Aye.
Aye. Those opposed, no. In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported. Without objection, a motion to reconsider is laid on the table. The next item for consideration is H.R. 563. The clerk will designate the bill.
H.R. 1563 to amend Title V United States Code to provide that individuals having seriously delinquent tax debts shall be ineligible for federal employment and for other purposes.
I ask unanimous consent the bill be considered as read and open for amendment at any point. Hearing no objections, so ordered. The Federal Employee Tax Accountability Act, Federal Employee Tax Accountability Act of 2015 makes individuals with tax debt that is seriously delinquent ineligible for a federal civilian job. The bill before the committee includes changes made at the request of the minority during prior markups, including changes exempting from termination employees who are making a conscious effort to pay their taxes or to dispute them. Much like we just passed out and we discussed on the bill regarding federal contractors, the principle, I think, is is sound, and it's simple, and it should be consistent. If you are legitimately trying to pay your taxes, if you're trying to go through the process, if you're disputing what the IRS is saying and going through the adjudication process, of course we're not going to terminate you or penalize you. But unfortunately, there are a series of people who don't pay their federal taxes. They just literally thumb their nose at the American taxpayers, and they say that we're not going to pay their taxes. That's just fundamentally not right. The President's fiscal year 2016 budget asked the American taxpayers to spend roughly $275 billion to pay federal workers an average salary of more than $78,000. The overwhelming majority, it's not even close, the overwhelming majority of people who work at the federal government, they're good, honest, decent, hardworking, patriotic people who do the right thing. They pay their taxes, they work hard, they try to contribute. We're not talking about those. We're talking about the people who are the bad apples, who spoil the system, they take advantage of the system. And we, I think, have a duty and responsibility to weed out those bad apples. The IRS literally yesterday came out with their annual report. It said that more than 100,000 federal civilian employees owed more than $1 billion in unpaid federal taxes in 2013. That's just fundamentally not right. It's just not right. In fact, I will tell you the legislative branch was one of the worst offenders. We're gonna be dealing with that bill here in a minute. I think it was more than 5% of the people that work in the legislative branch and serve as members of Congress, you don't know which ones are which, don't pay their federal taxes. So we got a bill that's going to come up and try to address that as well. But we have I think, a duty and obligation to address, quote, the serious delinquent tax debt that is defined as an outstanding federal tax debt that has been assessed and may be collected by levy or court proceedings. If you're trying to make good, if you're trying to get on the right track, if you're having your wages garnished, things like that, then this bill is not going to affect you. It does not affect employees that are working to settle their tax disputes. They're going to happen. You may get into a new marriage. You may have had an investment go bad. There are lots of legitimate reasons why you're having a tax challenge. If you're trying to make right and you're working it out, or you're challenging the IRS, this does not affect you. Several other safeguards are carved out in this bill. Individuals are provided full due process rights and have 180 days to demonstrate their debt meets one of the exemptions in the bill. For instance, having entered into an installment agreement. The bill also provides a financial hardship exemption if the individual's service is in the best interest of the United States. We have to make sure we got to clean up our own backyard. It does give the Secretary and senior members within the administration some discretion. But I do think we owe it to the taxpayers who are paying these bills. I get highly offended by those people who take the federal taxpayers but don't pay their own share of federal taxes. It just seems like common sense. I think we should treat it similar to the way we do with federal contractors, and therefore I introduced this bill. But I know some people have some objections, and that's why we have these discussions. So with that, I'll yield back and recognize anybody else who would like to speak on the bill. The ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. The Federal Employees Tax Accountability Act of 2015 is very similar to the bill you introduced last Congress. I opposed that bill when it was brought before this committee and to the House floor last Congress, and I am steadfast in opposing the bill now. Despite minor changes to the legislation from last Congress, the purpose and intent of the bill remain the same. It would require federal employee agencies to fire federal employees who fail to pay their taxes. Unlike the legislation in the last Congress, this bill would also allow employees to be disciplined for intentionally failing to file a tax return or intentionally underreporting their income. I strongly agree that everyone, including federal employees, should pay their taxes. However, the Chairman and my Republican colleagues seem to believe that there's a serious problem that requires a legislative fix. I disagree. According to the IRS, the 2014 tax compliance rate for the federal community is 97%. This percentage is higher than the 95% tax compliance rate for the House members and staff, and a much higher rate than the 91% compliance for the general public for 2013, the latest statistic available for the general public. Despite this exemplary compliance rate among federal employees, our colleagues believe that we need to adopt a new law that would apply only to these employees. I do not understand the need. For the 3% of federal employees who are not tax compliant, there are existing remedies to address noncompliance. Under current law and regulations, agencies can take disciplinary action against employees for failing to meet their tax obligations, ranging from counseling to outright removal. That's already in law. In addition, the IRS has a mechanism in place to recover funds from federal employees who are delinquent in paying their taxes, known as the Federal Payment Levy Program. Under this program, the IRS can impose a continuous levy on federal salaries and pensions up to 15% until the debt is paid. According to IRS, all federal employees are automatically subject to the Federal Payment Levy Program if they do not pay their taxes. But again, they are able to keep a job so that they can pay the taxes. Since the start of the levy program, the IRS has been extremely successful in recovering delinquent taxes from federal employees. According to the IRS, the levy program has collected over $5 billion since 2000. These facts indicate that the IRS is succeeding in recovering delinquent taxes in 100% or nearly all cases involving federal employees. Mr. Chairman, I don't see the problem with the federal government's ability to recover delinquent taxes from federal employees, so I do not understand why we are considering a change in the law to fix a problem that does not exist. Clearly, the legislation is designed to punish federal employees. I've said it many times that I just think so often federal employees are made to look to be viewed in a negative light, but they are the people who keep this place running. They're the people who keep us going as a country. In fact, the Joint Committee on Taxation concluded that the enactment of similar legislation would have a negligible impact on the revenue and increased costs to the taxpayers by requiring agencies to spend time and resources to review public records to find tax liens filed against current or prospective employees. For these reasons, I urge my colleagues to join me in opposing the measure. In addition, Mr. Chairman, I ask unanimous consent to enter into the record a letter from the National Treasury Employees Union opposing the legislation. I want to thank you. And with that,
Would the gentleman,
Without objection, so ordered.
would the gentleman yield?
of course.
I thank my friend. I wish to associate myself with his remarks. So we've had this debate before. I certainly appreciate what the chairman is trying to do, but I do think that in the context of the disparagement of the federal workforce, this bill has to be seen in that context. It is not well received by our workforce. They see it as another attack on them, and especially when there isn't really a problem in the federal workforce. Federal employees pay their taxes at a much higher rate. Their compliance rate is much higher than the general public, and so it's a bit of a solution in search of a problem. So I thank the ranking member for his sentiments, and I associate myself with his remarks.
Thank the gentleman.
Mr. Chairman,
Gentleman from Ohio.
I yield time to the chairman of the full committee.
Thank you. And listen, I appreciate that there are different sentiments on it. I get perhaps a bit sensitive about the idea that the intent of the bill, which I'm the primary sponsor, is done to disparage federal employees. I greatly appreciate federal employees. I have routinely, time and time again, in hearings and gone out of my way to thank the good men and women who serve. And there have been members who have duly noted the tax compliance rate in many ways, in many different factors, is better than what you see in the legislative branch and from members of Congress. So that is duly noted. We are talking about a very small percentage of people, but unfortunately, according to the IRS, there are about 100,000 that haven't paid about $1 billion a year, and that number goes up each year. Now, the IRS did something years ago that actually they now have the best compliance rate that there is, because they gave themselves the ability to weed out those bad apples and be able to actually let somebody go. It also says to somebody who's going to join the federal workforce that they are going to have to be right in terms of their tax liability moving forward. Now, the levy program was mentioned. It's a good program. And if you're going through that program, then you're not subject, or there won't be a consequence because of this bill. So if you're trying to make right, if you're having your wages garnished, if you're working out a settlement, if you're disputing what the IRS says, I mean, the IRS is not always right. They make a lot of mistakes there. Then yes, you're going to be just fine. But it does give some discretion to those people and to the Secretary to deal with this.
Would the gentleman yield for a question on this bill?
Gentleman from Ohio controls the time. Yes, go ahead.
If 97% are compliant with their tax obligation, I would think that they would want the other 3 to be compliant as well, particularly given the number of exceptions that exist in your bill. Could you go back through the exceptions again? Because as I understood the chairman's bill, this is for the willful failure to pay your taxes, and you list a litany of exceptions for which the federal employee could avail herself or himself. Could you go back through those exceptions again?
There are a whole series, thank the gentleman, there are a whole series of exceptions out there. For instance, individuals are provided a full due process rights and have 180 days to demonstrate their debt meets one of the exemptions in the bill. They have entered into an agreement. They maybe have a financial hardship. They may be, the Secretary has discretion if their continued employment is in the best interest of the United States of America. They can be going through a process, the adjudication process, where they're making their case. But once they've gone through that whole process and they've exhausted all of that, there comes a point where they need to actually do what you're supposed to do. And if we're going to hold contractors to that level of scrutiny, why not hold federal employees to that same level of scrutiny? The other thing that I would note is I did introduce a Members of Congress Tax Accountability Act. Now, that bill got referred to House administration. It doesn't come before our committee. But I would urge my colleagues to make sure that we also, as members of Congress and the legislative branch, also are held accountable to these same standards. And so there are disclosure requirements that we placed on members of Congress. There's a garnishment program that would have to be implemented. And I think it should be true here too as well. It is a privilege, it is an honor to work for the federal government. And the overwhelming majority of people do it the right way. But for those few bad apples, let's give a tool to the Secretary so that they can have some discretion to weed out those people who are literally thumbing their nose at the American people who are paying their salary, and do so and put this in context that, again, the overwhelming majority do it, and they do it in the right way.
Would my friend yield just
Of course.
quick clarification? I just want to be very clear. My reference to disparagement was not about you or this bill. It was the context of the last 5 years. I represent the third largest number of federal employees, and they feel under assault. But I want to be very clear.
I think
in
that
no way did my comments reflect on the chair.
Understood. Understood.
Thank
I thank you. And but I appreciate having this discussion. That's what we're supposed to be doing here. So, the gentleman from District of Columbia is recognized for 5 minutes.
Mr. Chairman, I know that the IRS has the remedy of garnishment available to it. Is that not available to other federal agencies? So why does, why isn't there an automatic
The
remedy?
gentlewoman would yield, garnishment is available, and if they are having their wages garnished.
Do they
if
have to consent to have that?
No, then the bill does not affect them. But there are a percentage of the 100,000 who aren't having their wages garnished. They're saying no to everything. They're not paying their federal taxes.
But why isn't the garnishment automatic? Why isn't the remedy available to the agency to garnish the wages?
Some of the, if the gentlewoman would yield, some of them have limitations, that 15% cap. Other people, flat out, just simply say, no, I'm not doing it.
Well, I thought garnishment of wages was not open to permission. I thought the government or whoever's the employer simply takes back some of your wages until it's paid off. And I don't know why the agency wouldn't use the remedy available to it if it has such an employee.
Not all cases end up in garnishment. The other thing that I think is an important part of what this bill does is for people that are applying to come here, again, if they're good with the law, if they're good with the IRS, if they're going through the adjudication process, if they're having wages garnished or want to have them garnished when they start the process, then they're fine. This bill will not affect them.
Mr. Chair, I would just ask for clarification before this bill goes to the floor. If there is an automatic remedy available to the agency, rather than to select out federal employees for this kind of admonition, I would call upon the agencies to use the remedies automatically available to it, just as employers throughout the country use such an available remedy. So I need more clarification on why that remedy isn't automatically available and why it wouldn't be used in this case. I remember the IRS case. And I don't, where garnishment is used there, and I don't know what would be the difference. I mean, all these people are being paid by the federal government, and I can understand that from the point of view of, I don't know, the hardworking American. If you're getting your money from the federal government, they ought to pay your wages, and ought to pay your taxes. And I also understand what we learned, for example, about where most of these most debts come from. They have come overwhelmingly from healthcare expenses. In light of the fact that very few people, particularly those who work for the federal government, would say, I work for the federal government, but I'll be darned if I'm going to pay my taxes, it would seem to me, and I appreciate that that your bill does incorporate deferences to the employee and to due process, but I would think that the way to deal with this is for the executive agency to use the processes available to it when it comes upon an employee who simply won't pay his taxes, and you already have other remedies, as the ranking member said, available to you. If there's somebody who really says, no, I'm just not going to do it, then you have other remedies in addition to garnishment available. So I think we need to explore whether or not the agencies are assuming the burden which is theirs as well.
Would the gentlelady yield?
We
Just-
please
just
to yield
one-
to the ranking member.
Thank you. Just one bit of clarification, too. It's my understanding that the 100,000 people who are delinquent, that also includes the people who are in the levy program. That you didn't talk about that, but the levy program already, and so that's
my
so I
goodness,
yield
so-
back.
well,
So
just
it's
a
actually the
moment.
number is actually
Those numbers include people whose wages are being paid back to the government by garnishment?
yes
It
under the levy program.
doesn't seem to me that that's fair. It seems to me they're paying the government exactly what we want them to do. And the government is doing the right thing. You owe me money, and I have a process available to me. I'm
Will-
using
will the
that
gentleman-
process.
will the gentlewoman
And then we
yield?
should use another process, the process that the ranking member said, if we have a person that is, that needs to be fired or sometimes needs to be disciplined.
Will the gentlewoman yield?
Yes, sir.
If they're going through the levy program, then the bill does not affect them. But there are a percentage of those people that aren't going through the levy program. There are people, for instance, that if they owe less than $10,000, the IRS often will not go through the garnishment program.
Why won't they? I don't understand that.
It's just IRS policy, and so we're not trying to put we got to be careful on how we put government agencies in between what an employee and the IRS and their tax obligation, but there comes a point where it gets to be to a point where this information does become public because they actually go out and make this information available. All we're trying to do is give a tool to a secretary to have that sort of discretion. What happened was, at the IRS, they had this problem. They were terribly embarrassed by it. They implemented this, and guess what? Now they have the single best compliance rate that there is. Still not perfect, but it improved the number and the percentage of people that were actually paying. And so we're just trying to give some discretion to those secretaries and heads of agencies to have this tool available if they really have this bad apple who's not paying their taxes. We did the same thing for contractors. We should do the same thing.
The gentleman would
for-
yield. It seems to me that there are other. I want to start with garnishment. If the point is to get the money that is owed the government, there should be no discretion, it seems to me, on the part of the government not to get the money that's owed the government. And the burden should be on the agency to get the money that's owed the government if it has a tool. And I need information to know whether agencies have the discretion to use that tool and when they are not allowed to use that tool before I could vote for this bill.
If the gentleman will yield.
Please yield.
That is a tool that the IRS can use, and that is between the employee or anybody. You don't have to be a federal employee. It's up to the IRS to do that. But there are still a percentage of people who thumb their nose at it and refuse to pay. It happens in the
Would the
private
gentleman yield?
sector.
Could they refuse?
It happens in the federal government.
Would gentleman yield? If garnishment is in place, how could you be refusing? That is a tool of the government, which in essence says that we are collecting our money because you have refused.
If the gentleman will yield, garnishment is not always put into place. It's just.
My only question is, why not? That is the only question I'm raising here this morning.
Well,
Why isn't it always put
if the
into
gentleman-
place?
gentlewoman-
And isn't it the better remedy for federal employees, just as it is used for employees throughout the American workplace?
If the gentleman will yield, I will continue to work with you on this.
Thank you.
I think it's a very legitimate question. They use some discretion. There are certain thresholds in which they do it and they don't do it. But I will continue to work with you and hope that this will move to the floor.
Just, gentlemen,
Yes.
somebody yield. Just only take a second. As I listen to the discussion, the question also becomes, if you don't have any job, you can't pay anything. I mean, but I mean, that's something to think about out of all of this, all the things that you're talking about, even garnishment. If you don't have a job, then you are probably getting money from the government some kind of way to sustain yourself, food stamps. I mean, you can't pay because you don't have any money.
If the gentleman would yield, and if your wages are being garnished, you are paying the government, and you at the last resort, and I don't see where anybody has a grievance. So I would very much appreciate what the chairman says
We
about
will continue to work with you.
clarification.
Thank the gentleman. Does any other member wish to be heard on the bill?
Could I just ask a
Gentleman
question?
from Virginia is recognized.
Just a question of the chairman. We had a hearing, Mr. Meadows and I, on your bill last week. And I think it's important, correct me if I'm wrong, Mr. Chairman, the IRS is in possession of the information of whether a federal employee owes taxes. But the manager, supervisor of the respective federal agency will not be privy to that information. Is that not correct?
There is, if the gentleman will yield.
Of course.
There is a process and a point where that information does become public. You can go down and check if it does become public. There's also, as a point of employment, to be able to say that you would voluntarily give this information up. I think it's, again, there's a couple different components to this bill. One is somebody who's applying. you should have to be able to declare that you're good with the law and you're good with what you're doing with taxes. So I think that is addressed. It's just this basic principle of,
Well, I thought the chairman made a good point in his opening remarks on his legislation about preserving privacy. I just want to underscore, based on the testimony we heard at our hearing, federal managers do not routinely get informed, even in the case of tax delinquency. That information is available to the IRS, not necessarily, in fact, routinely not to the federal manager in question. So they may not know what percentage of their workforce, if any, are in fact delinquent in their taxes. I thank the chair.
thank the gentleman. Does any other member wish to be heard on the bill?
Mr. Chairman.
Yes, gentleman.
Mr. Chairman, as a matter of principle, I think all of us on this entire committee agree we dislike tax cheats. We dislike anybody who would presume to thumb his or her nose at the American public when it comes time to paying taxes. But by the same token, anybody who has employed people in the private sector understands that if you want to get the most out of people, if you want to get the best people working for you, you not only have to pay them the fair rate, but you also have to treat them fairly. And not treat them like the enemy, not treat them like criminals, not treat them like second-class citizens. And that's my fear about this bill. You know, Mr. Chairman, you mentioned 100,000 people who are federal employees who are behind in their taxes, and that adds up to $1 billion in lost revenue to our nation. And statistics, what was it Will Rogers says? There's statistics and then there's some kind of lies.
There's lies, there's blank lies, and then there's statistics.
Yeah, I can always count on my friend from South Carolina to help out. But when I hear statistics, I always want to put them in context. And when I hear 100,000 people behind on their taxes who are working as federal employees, I wonder, what about the private sector? What is the corresponding number for people in the private sector? And when I hear about $1 billion in lost revenue in taxes from federal employees who are not up to date on their taxes, I think about what is that number for the private sector? Well, you know it's not 100,000 in the private sector. It's in the millions of Americans.
Will the gentleman yield?
Just a moment. Sure. It's in the millions for people behind on their taxes in the private sector, and it's not $1 billion in the private sector. It's hundreds of billions of dollars. And so the question is, why are we focusing on the small potatoes when we should be focusing on the big potatoes? You know, as the ranking member has noted, we have this federal employee levy program in place already. You know, we have a mechanism where we can access the money for federal employees at its source. We don't have that remedy when it comes to the private sector. So when you're talking about collecting the past due hundreds of billions of dollars owing to the American public, we ought to be focusing on the tax cheats, those people who are thumbing their noses at the American public in the private sector, and not so much treating our federal employees as whipping boys as we have been. And I yield back, Mr. Chairman.
Gentleman from North Carolina, Mr. Meadows, is recognized.
Thank you, Mr. Chairman. Let me make sure that we're very clear as it relates to federal employees. 97% of federal employees are paying their taxes. So when we talk about whipping boys, I mean, it's important that we note that 97% of the people are paying their taxes. So it's really a spirit of fairness at a time, too. What do we tell the 97% of the federal employees who pay their taxes every year? Why would it be fair to them to say that somebody else gets a free pass? Now, I say that because the ranking member of the subcommittee, Mr. Conley, and I have had this discussion because so many times, and oftentimes in this particular committee, some of the federal employees get tainted by the bad apples. And it is, and I know that we have agreed to make sure that the federal employees get acknowledged in the way that they should, that the vast majority of them do an outstanding job each and every day. But I would like to point out, and I've talked to the chairman about this, because the only other way to really address this issue is to potentially force the IRS to act quicker in terms of collecting and using the tools that are already available to them, which ultimately then allows the discretionary part of a manager or anybody in these agencies to make those hardship cases where because we all think of ourselves in that hardship case. We don't think of the deadbeats. We think about, the husband or the wife who has had issues, the family members that's had issues. And so in this, we know that the IRS has been able to put forth a policy that actually makes it much better. This is a less draconian way of making sure that we deal with this, because if not, the American taxpayer on Main Street has a hard time figuring out why, if we're paying employees with federal dollars, why they don't pay their federal taxes. And I yield back.
Thank the gentleman. The gentlewoman's from organized.
Thank you, Mr. Chairman. I also 100% agree that if you are a federal employee and the fact that your salary and wages and benefits are being paid by taxpayers, that you absolutely should be paying your federal taxes. But there are so many exceptions to that. And if I could just bring up an issue of a spouse who literally, and I would like to use the case of a woman who was an at-home mom, and because of decisions made by the working spouse, or it could be either way, they are now in a tax problem. That person seeks employment, and that person will be denied or fired from the job because of decisions that were made. It's so many complexities here. I absolutely say that our opportunity here is to strengthen and to make sure we close those loopholes that can be used by a federal employee. And I would even entertain the conversation that if you're a federal employee, that the garnishment of your salary will be immediate if you do not pay your taxes. But to say that you will lose your employment because of the complexities of why a person, and sometimes out of, and I can tell you, there has been many cases in divorces and other things where there's a liability to a person.
Will the gentlewoman yield?
Yes.
Under the two scenarios that you've laid out,
Yes.
not affected by this bill. I mean, it doesn't affect you've got an exemption under this bill. The bill is really going to try to root out the people that don't fall in those two cases, because you're right, there are a lot of people that fall into that.
And if you yield back, so where does the burden of proof lie? So now we have a situation where, so I think we need to work through this more, because if I need this exception, what is the burden of my responsibility? Are there legal? Is it application? And at what point do I plead my case? Is there a decision made? I need more information to be supportive of this. I want to get to the point where our federal employees are paying their taxes, but there's just so many complexities. And until we answer the question that my colleague from the District of Columbia asked, what are the restrictions to applying garnishment to a federal employee who's not paying their federal taxes? Thank you. I yield my time.
Thank the gentlewoman. And we look forward to continuing to work with you, because in previous markups and discussions, we added some amendments to help strengthen that process and give more time to go through that. We added 180 days, for instance, that was part of this process. So I think we've made it stronger, but we want to win you over, too, before we go to the floor. So,
Thank you.
the gentleman from Massachusetts.
Sure. Thank you, Mr. Chairman. We've seen different versions of this bill in the past, and When we drilled down on the numbers of those folks who were delinquent in their taxes as federal employees, by and large, the number, those individuals were people who had health care crises in their family, those who had, and personally, those who had divorces going on, which has been mentioned here earlier. But the stumbling block here in the past, and it remains that way, is that federal managers, whether it's your foreman or whether it's the administrator in your office as a federal employee, they are prohibited right now by law from delving into your personal tax information. Now, the IRS has a different capacity, and they are allowed. But if we are going to now deputize managers at the VA, managers at State Department, managers at every federal agent, Department of Justice, now they are going to become investigators for tax purposes to delve into the reason that you might be behind on your taxes, whether or not they discover that on their own or they're informed otherwise. But you realize what you're doing here, that for federal employees, all of that privacy goes away. You're going to have to affirmatively defend your failure to pay taxes or to be being delinquent. You're going to have to explain, well, I have a medical issue, or my family has a medical issue, or I am going through a divorce. You're going to have to affirmatively put that reason forward so that you can get the exemption. And, look, that is not a way to treat federal employees when you're talking about 97% of them are paying their taxes already. If you have to, let the IRS do their job and not turn these managers, your foreman, the person you work with every day in your office is now going to become an official or an agent for the IRS to recover your taxes.
If the gentleman will yield, the characterization that you're putting to that is just simply not true.
Well, how does it happen then? How does it happen then?
Because there comes a point.
Someone's going to fire you. It's going to be your boss. Right? So they're going to have to, well, reclaiming my time. How do they know? How do they know that you're behind in your taxes? Because they're going to have to become part of this whole process. The people you work for in your office. This is silliness. Look, if people are behind on their taxes, have the IRS go after them the way they're supposed to go after them. But you shouldn't enlist the managers in the offices of these people and their coworkers in terms of delving into their private situation. That's all.
The gentleman will yield.
I'll yield.
We have accepted in the past every amendment that you've offered. I think it's strengthened the bill. Number two, if you pay your federal taxes, you don't have a problem. If you're in a garnishment program or the levy program, you're not part of this bill. It doesn't affect you. But I would hope that there'd be some recognition that there are some people, despite all those other outlets, that still say, no, I'm not paying. I'm not doing it. I'm sorry. And they're getting paid by the federal taxpayers. And remember,
so we're going to treat everybody like a criminal because there's 0.0001 person out there that's doing the wrong thing. So let's treat them all. Let's open them all to public humiliation. And the garnishment program, when we looked at this last time, the garnishment and levy program is when people get behind on their taxes for reasons of health care or divorce and things like that, they're embarrassed. They do not come forward. So usually what happens is we'll put a lien, and then they'll agree. The IRS will put a lien, not Congress. The IRS will put a lien, and then as a way to pay back their taxes, they agree to garnishment and levy. That's how that works. So they're not just stepping up, just come on in and sign up for the levy program or the garnishment program and everything will be fine. That's not how it happens. Usually there's a financial collapse there, and the levy or the garnishment program is more a way to sort of manage their way out of this thing. But I think this is overreaching in a huge respect. I think that it's we come out of this committee, time and time again with ways to punish our federal employees, and 97% of them are paying their taxes, and 97% of them are probably doing a very good job at their.
Will the gentleman yield?
Sure I will.
One of the first bills we moved out of this committee was your bill. It wasn't punishing federal employees. It was benefiting people who are veterans. I take exception to the idea that every time we turn around, we're just punishing federal employees. We're going to punish the bad apples.
Let's put it this way, you know, when we freeze folks' pay, it seems like more and more burdens going on the federal employees, that we target them for, you know, freeze their pay, furloughs.
Pay your
know.
taxes and there won't be a problem.
Yeah, right.
Gentleman from California.
Thank you, Mr. Chairman. I have two questions. At what point does a federal employee get a serious delinquent tax debt? Is that multiple steps before someone gets to that status? And then once someone gets that status, what criteria does the agency have in determining whether they should terminate that employee or not?
To try to answer the first part of the question, and we're going to have to work with you in more in depth, but there comes a point where if the IRS is pursuing an individual, regardless of whether or not they're a federal employee, and they place a lien on their property or against that individual, that becomes a public record. Up until then, there really isn't a public exposure other than they give us percentages based on a report that was generated because the IRS tax delinquency rate was so high that they decided, Congress, before I was here, to generate an annual report and tell us in sweeping generalities which departments, agencies, who has what, you know, sort of non-compliance. But it becomes a public record when the IRS goes out and places a public lien. From there, this bill has a series of steps that gets to a point where a decision has to be made. And the other thing that I would draw the gentleman's attention to is people who are going to apply for these jobs. And I think we have a duty and responsibility to see where they're at in that process. And again, if you're trying to make right, trying to do the right thing, you've had a collapse, whether it's medical or married somebody or you made a bad investment. I mean, there infinite number of reasons why you can get yourself wrong. But if you're trying to get right, this doesn't affect you. And we'll continue to work with you because I think there's some other steps and things you brought up that we can further lay out. Yes, the gentlewoman from the Virgin Islands is recognized.
Thank you. Good morning, Mr. Chairman, Ranking Member. I had questions regarding the applicants. One of the things I wanted to point out, and most respectfully, Mr. Chairman, I had a problem with that exchange just there where you talk about we're going to punish the bad apples. And I'm not entirely clear if, and I know I'm a freshman, that if it's our responsibility to punish people, I think that's what the courts are for. And it's our jobs to make sure that there's a smooth and efficient use of government. And with that in mind, one of my concerns is that, how does this increase or guarantee an increase in those individuals paying taxes? This is going to be a cost to the federal government as well in the first year of this. It's been my understanding that passing this legislation will be a cost and will not necessarily guarantee that individuals will in fact pay. And I also have a concern that it will cause applicants, because the bill doesn't just affect existing employees, but those who are applying. And individuals may feel, very good individuals may feel discouraged to apply for federal employment if they then have to go to those individuals who they are applying to and ask and divulge their personal business. Maybe things that have happened in their past that they don't feel necessarily comfortable discussing, and really has nothing to do with them carrying out the duties for which they are applying. And then they've got to discuss bad decisions, bad divorces, medical issues that they may have that really may even go against HIPAA laws in terms of them divulging medical information or their employers having medical information that has caused them to be in the debt. So again, my concern is, one, that I don't necessarily believe that it's our function to punish people, that there are laws on the books for that we should be concerned about making sure that we're efficiently running government, and this is going to be a cost, not necessarily a way to increase revenues into the federal government, and that it may be a real discouragement to individuals who are applying for work from coming into the federal government. We had a hearing yesterday where we were concerned about the types of employees that were coming into our Secret Service and wanting greater pool of individuals who are applying. And just because someone has financial issues does not mean that they're not able to do the work of the federal government. And that's my concern with the legislation. I hope that you would speak to that. Is the gentlewoman from the District of Columbia, if I could yield some of my
Sure,
time to her?
sure.
I just want to be clear that I don't have any problem if a person has a medical debt from forwarding that as a reason why there should be some relief and some reason not to proceed against him. If you have a personal reason why you're in debt, and I want you to know it, and I'm willing to say that, I don't have any problem with that. But I think we can avoid all of that by putting the burden on the government to garnish you. Then if you want to come forward and say, just a moment, I have a personal problem, that'd be one thing. But I think that, look, you owe this money to the government, and I don't want to be misunderstood, and I think the members have been clear about not wanting to be misunderstood. We are not special pleaders for people who get paid by the federal government. There's no way in which I can go to my constituents and say, well, I can tell you one thing, they're not going to do anything to my federal employees. But at the same time, you have people who make far less money than federal employees who are your constituents whose wages are being garnished every single day. And I don't know why, if that remedy is available to employers throughout the United States, we shouldn't, if it's reform of our garnishment laws that are necessary, if it's reform of our levy laws that are necessary, then I think that is the remedy that should at least precede this bill or be a part of this bill.
Thank the gentlewoman. Does any other member wish to be heard? Prior to my recognizing the gentlewoman, I think we're going to have to go into recess. As we previously announced, we have the President of Afghanistan addressing a Congress. Members were asked to be on the floor at roughly 10:30. It now being 10:30, we're going to stand in recess. The committee will reconvene 15 minutes after the conclusion of the Afghan President's comments. We stand in recess. committee will come back to order. We appreciate those members and the opportunity to hear from the President of Afghanistan, who's visiting with Congress. But as we had given prior notice, it's been a good almost 25 minutes now since the comments from the Afghan President have concluded, and so we are coming back into session. I would now recognize the Ranking Member, Mr. Cummings, for 5 minutes.
Mr. Chairman, I want to thank you for allowing the committee to actually flesh out their concerns about the bill. And but I just want to make sure that we recognize something. I think it was Ms. Plaskett who brought out something that I don't know whether all of us were listening, but it was very important. Under current law, agencies have the discretion to consider mitigating factors regarding a tax liability. For example, even in the context of a security clearance application, current adjudicative standards allow agencies discretion to grant a security clearance to an applicant with a tax delinquency if there are mitigating circumstances. So this legislation would take away that discretion. The 97% tax compliance rate of the federal community does not justify changing the current law. In addition, Mr. Chairman, the IRS has noted that the 100,000 federal employees who are noted as delinquent in their taxes includes those who are in the federal payment levy program, those whose debts the IRS determined were uncollectible, those who are in litigation over their debt, and those who have entered into a compromise offer with the IRS. So, in effect, the 100,000 figure is an overestimate of the federal employees who are not paying their debts. I just think that we need to be clear on those facts as we proceed. You know, when we think about young people trying to come into the employment of the federal government, a lot of times, unfortunately, they have not been able to find jobs, or they've run into hardships. And I think the idea that there could be discretion with regard to these issues before, and now the discretion disappears, that should concern us all. We're trying to open the doors for more and more federal employees. So many of our federal employees are now reaching retirement age, and we're trying to attract the brightest. And we also know that people, a lot of times, and probably many of us, in our younger years, some of us are still very young, but us older folks, ran into difficulties ourselves, and we were able to correct them. So, anyway, I just want to make that note, and I'll yield back on that.
Thank the gentleman. Does any other member wish to be heard on this bill? Does any member have an amendment to this bill? If there are none, the question is now on the adoption and favorably reporting H.R. 1563 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
In the opinion of the chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. The next item for consideration is H.R. 1557. The clerk will designate the bill.
H.R. 1557 to amend the Notification and Federal Employee Anti-Discrimination and Retaliation Act of 2002 to strengthen federal anti-discrimination laws enforced by the Equal Employment Opportunity Commission and expand accountability within the federal government and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objections, so ordered. This is a good bill, and I'm going to yield first to the gentleman, the author of this bill, Mr. Cummings, for 5 minutes.
Thank you very much, Mr. Chairman. And I want to thank your staff for working so closely with mine as we developed this legislation, and they did work very, very hard, and we do appreciate it. I also want to thank Congresswoman Eleanor Holmes Norton for co-sponsoring this bill. Her expertise in equal employment law and her experience administering the equal employment opportunity programs are unmatched in the Congress. Finally, I want to thank Tanya Ward Jordan, Paulette Taylor, and all the members of the Coalition for Change, C4C, for their work on this legislation and for their dedication to ending discrimination in federal employment. I thank them also for their work helping federal employees understand their rights and navigate the EEO process. C4C has written a letter supporting H.R. 1557. The Make It Safe Coalition has also written a letter in support of this measure. Mr. Chairman, I ask unanimous consent that both letters be entered into the record.
Without objection.
Thank you very much. Federal EEO programs are critical to ensuring that federal workplaces are free from discrimination and that any barriers impeding fairness in personnel decisions are identified and eliminated. These programs are essential to ensuring that our federal workplaces uphold the guarantee of equal opportunity that is the right of every citizen in this nation. And if discrimination occurs, these programs must be able to investigate and adjudicate employee complaints impartially and in a timely manner. In fiscal year 2012, federal employees and job applicants filed nearly 16,000 complaints alleging they had been victims of discrimination. While the vast majority of federal workplaces are in compliance with current EEO requirements, some federal agencies still have not met the standards of a model EEO program set forth by the Equal Employment Opportunity Commission. For example, in 2014, the EEOC issued a report on the Social Security Administration that made 12 findings regarding Social Security's failure to maintain a model EEOC program, ensure efficient management of the various stages of complaint process, provide uniform training to ensure equal opportunities, and implement effective and efficient anti-harassment policies and procedures. The EEOC made more than 60 recommendations for reform of that program. My bill would require that EEO programs operate independently of an agency's human resources or general counsel offices, and that the head of the program report directly to the head of an agency. This would ensure that effective implementation of the EEO program is prioritized at the highest level of an agency, and that the program is operated with the sole purpose of ensuring equal opportunity for all employees. H.R. 1557 would also strengthen the accountability mechanisms that are central to effectiveness at the EEO process. This legislation would expand the notifications that agencies are required to provide when discrimination is found to have occurred, and it would require agencies to track and report whether such findings have resulted in any disciplinary action. Finally, the Act would prohibit the use of non-disclosure agreements that restrict an employee from disclosing to Congress, the Office of Special Counsel, or an Inspector General any information that relates to any violation of any law, rule, or regulations, or instance of waste, fraud, or abuse. According to 2014 Federal Employee Viewpoint Survey, only 6% of federal employees agreed that they could, quote, disclose a suspected violation of any law, rule, or regulation without reprisal. We're better than that. Employees need to have confidence that they can report an act of discrimination without suffering retaliation, and they need to know that such reports will be thoroughly, fairly, and timely investigated and adjudicated. The Federal Employee Anti-Discrimination Act will strengthen existing requirements to ensure federal EEO programs meet these standards and that agency management of the EEO process follows best practices available. I thank you again for working with me, and again, I want to thank Ms. Norton for all of her help. It's been absolutely invaluable. With that, I yield back.
Thank the gentleman. I'll now recognize myself for 5 minutes. The Federal Employee Anti-Discrimination Act is a good government accountability introduced by Mr. Cummings. I feel comfortable with this bill. In fact, would like to add my name as a co-sponsor of this bill prior to it moving to the floor. I understand the legislation was developed in response to an EEOC program evaluation report for the Baltimore office of the Social Security Administration. That report noted serious issues concerning the implementation of the Social Security Administration's procedures to resolve harassment and discrimination disputes. The bill does a number of good things to increase transparency and accountability, including requiring agencies to provide electronic notification to employees when a discriminatory or retaliatory action occurs, mandating agencies and the EEOC to post additional information about no-fear violations on their websites, and requiring agencies to develop a system to track no-fear complaints from inception to their final action. Again, I thank Mr. Cummings and Ms. Norton for their good work on this bill. Again, I'm glad to add my name as a co-sponsor to that as we move forward, and urge my colleagues to support this legislation. With that, I'll yield back. Does any other member wish to speak on this piece of legislation? The gentlewoman from the District of Columbia, Ms. Norton, is recognized for 5 minutes.
Mr. Chairman, I certainly want to thank you for working closely with the ranking member, and the ranking member in turn for consulting with me on this, I think, very good bipartisan bill. When I chaired the agency, we could not have said, in fact, when I came in, one of the things I had to do didn't have much to do with discrimination. It had to do with making sure that complaints were handled in a timely fashion. And what I did was to try to resolve as many of them without going to litigation, to streamline the process. I think it's important for members to recognize that in our system, the first line of complaint really goes to the agency itself. And so you want to make sure that there's transparency in how that is handled and accountability, since the agency, in fact, or part of the agency is investigating discrimination complaints filed against the agency itself. Now, that doesn't mean that's the last place it goes, but many of them are or should be resolved at that point. Interestingly, I was interested in what could have been the impression that who is responsible for discrimination in an agency is the employee rather than the agency. For example, if you commit a tort, who is responsible for the tort is the streetcar company or the company who you're employed with. Here, who's responsible is the agency, unless you are personally retaliating or you are personally discriminating. And I want to thank the ranking member for working closely with me at the same time that he made sure that the employees were, who filed complaints were being protected, that employees who might be named simply because they were an agent of the agency were not personally accountable, since the agency itself is accountable unless, of course, there is some deliberate and illegal act by the employee who, for example, supervises, in which case that employee under this legislation would be entitled to due process as well. So I think this is a bill that all of us can support enthusiastically. I'd be glad to yield to the ranking member.
Just one note, Mr. Chairman. I just want to note that Social Security Administration is in my district, the administrator, Carolyn Colvin, at Social Security has moved to address a number of the concerns that this legislation aims to try to address. But we want to make sure it's in law, not a temporary fix, but something that goes on beyond the time that we are here in this Congress. And with that, I yield back.
Does the gentlewoman yield back? Gentlewoman yields back. Does any other member wish to be heard on this bill? Does any other member have an amendment to the bill? If there are none, the question is now on the adoption and favorably reporting H.R. 1557 to the House of Representatives. Those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Next item for consideration is H.R. 1531. The clerk will designate the bill.
H.R. 1531 to amend Title V United States Code to provide a pathway for temporary seasonal employees in federal land management agencies to compete for vacant permanent positions under internal merit promotion procedures and for other purposes.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. I'd now actually like to recognize the gentleman from Virginia, the sponsor of this bill, Mr. Conley, for 5 minutes.
I thank the Chair and the Ranking Member, and I thank them for putting this bill on today's markup. This bill is really about a matter, I think, of simple justice. We have thousands of seasonal workers, year after year, season after season, mostly in the western states, who put themselves at risk to put out wildfires, some of them enormous. And every year we, in fact, have casualties. But because they are deemed seasonal and temporary, they are actually ineligible for competing with federal positions. This bill does not create a single federal position. It simply allows this category of workers to compete when there are openings as if they were a normal, regular federal employee. It has been a problem for many, many years, and our colleagues who represent the West, including, I'm sure, yourself, Mr. Chairman, recognize this problem. That's why I'm so pleased that Rob Bishop, our Republican colleague, chairman of the Natural Resources Committee, is an original co-sponsor of this bill, as is Don Young from Alaska, another Republican colleague, very senior member of the Appropriations Bill. They recognize that this is something that has long been overlooked, and it is a relatively modest adjustment and a matter of simple justice. And so that's really what it is. And I could give the longer version, Mr. Chairman, but it's late in the day, and I'm happy to certainly give that longer version. But in the interest of comedy, I'd ask unanimous consent that my full statement be entered into the record.
Without objection, so ordered.
And again, I thank the Chair and Ranking Member for putting this on the agenda today.
I thank the gentleman. I now recognize myself for 5 minutes in support of this Land Management Workforce Flexibility Act. I do recognize the chairman of the Natural Resources Committee, Mr. Bishop, the former chairman of the Natural Resources Committee, Mr. Young, are enthusiastic and supporters and co-sponsors, original co-sponsor in the case, in their case, which allows for temporary workers to compete for full-time permanent positions to become available. Glad to have it on the calendar. It should be addressed, and very supportive of this bill. With that, I yield back. Does any other member wish to speak on the bill?
Chairman.
Mr. Cummings.
Chairman, I wholeheartedly support the bill. Mr. Connolly is absolutely right. This is only fair that we do this. And in light of the fact, Mr. Chairman, that Mr. Connolly, who usually takes more than his time, said that he wanted an abbreviated statement, I have to follow his lead, and I won't I'll just submit my statement for the record.
I would just point out it's a new day here at the Oversight and Government Reform Committee.
I yield back.
Thank the gentleman. Does any other member wish to speak on the bill in that context? Does any member wish to offer an amendment? Hearing none, the question is now on the adoption and favorably reporting H.R. 1531 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it, and the bill is ordered favorably reported. Without objection, the motion to reconsider is laid on the table. Our final bill today is under consideration is H.R. 651. The clerk will designate the bill.
H.R. 651 to designate the facility of the United States Postal Service located at 820 Elmwood Avenue.
I ask unanimous consent that the bill be considered as read and open for amendment at any point. Hearing no objection, so ordered. H.R. 651 designates the facility of the United States Postal Service located at 820 Elmwood Avenue in Providence, Rhode Island, as the Sister Ann Keefe Post Office. This bill is offered by one of my favorite members in this whole body, Mr. Cicilline of Rhode Island. He is a good and genuine person, and he has got broad support for this. I've talked to him on the floor about Sister Ann Keefe and the wonderful human being and unbelievable service that she had given that community, and how that community had rallied to her support and loved her and cared for her, and would encourage my members to do this. It's something important to Mr. Cicilline, and it's the kind of thing that we should do. And with that, I will yield back. Gentleman from Maryland, Ranking Member Mr. Cummings.
Mr. Chairman, we've reviewed the post office naming bill before us and agree that it meets the committee requirements. I support the bill and urge all of our members to vote in favor of it. I yield back.
Thank the gentleman. Does any other member wish to speak on the bill? Any member offer an amendment to the bill? If there are none, the question is now on the adoption and favorably reporting H.R. 651 to the House of Representatives. All those in favor signify by saying aye. Aye. Those opposed, no. In the opinion of the Chair, the ayes have it, and the bill is favorably reported. Without objection, the motion to reconsider is laid on the table. Without objection, pursuant to Clause 2L of the House Rule 11, members will have 2 days to submit views on the bills considered today. I ask unanimous consent that the staff be allowed to make necessary technical and conforming changes to the bills ordered reported today, subject to approval of the minority. Hearing no objection, so ordered. I would thank members for their attendance, and I appreciate the dialogue and discussion. This is the way these markups should go, and appreciate that we do have differences. We can air them out. That's what this body is supposed to be doing. So I think it was a productive morning and early afternoon. So I thank the members, and if there's no further business, without objection, the committee stands adjourned.